Good morning and welcome to today's webinar, Understanding Estate and Trust Administration, presented by Elville & Associates Managing Principal and Lead Attorney, Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's presentation. So welcome to those that are new to our educational webinar series and also to those that are frequent attendees. We welcome your general questions today, so please note them in the questions panel on your screen, and we'll pause periodically throughout the presentation to address them. Your questions really help the presentation and add value. They help others learn, so don't be shy in posing your questions at any time. You received the presentation and two checklists Steve will be referencing by email from me yesterday to take notes on them if you wish. The presentation and checklists are also available in the section marked handouts in the panel on your screen to download at this time. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a couple minutes to fill out this brief survey to offer us your feedback about the presentation. And as always, we read and value every comment. Here at Elville & Associates, we always want to be a resource to you for your families and your planning needs. So consider a consultation or document review with Steve after today's presentation, and use today's education as a jumping off point to get your planning started. Consultations are a great way to get your specific questions answered, have Steve understand your overall situation, and help create a solution and path forward for you. So before we get started, we're going to have a brief poll, but I'd like to offer Steve and the firm a proper introduction for those that are new to our webinar series. So you should be able to see my screen here. Elville & Associates, we were founded in 2010 in Columbia by Steve Elville. We have several different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, how about that? Business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do focus on education here a lot at Elville & Associates. We do that in several ways through our planning processes with our clients. We offer about 100 educational webinars and workshops in the communities we serve each year, and also by way of our accredited client care program, or CCP as we call it here. We're one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker. If you haven't heard Steve present before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time and 7th consecutive year in 2023. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am very privileged to be the executive director of. So if you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me, and I'd be very happy to share our story with you when we have just a little bit more time. But today we're going to learn and understand a bit more about estate and trust administration, and something that I'm sure many of us have dealt with in some capacity in our lives. But first, I'd like to learn, and Steve would like to learn, what has brought you here today, and what has your experience been with estate and trust administration to date? So I'm going to launch that poll. There we go. And your choices are, I have been the executor of an estate in the past on my own. Second, as an executor, I sought professional guidance throughout. Third, I may be asked to be an executor of an estate in the future. Fourth, I want to keep my planning in order to keep costs down. Or lastly, I'm an advisor here to learn to better serve my clients. So make the choice that best suits your situation, and then we're going to go ahead and get started. We appreciate you being here on what I hear will be a nice day out there today. Hard to believe it's already March. Give it another couple seconds. Okay, so we have 14% say I've been the executor of an estate in the past on my own. 5% say as an executor, I sought professional guidance throughout. 38% say I may be asked to be an executor of an estate in the future. 33% say I want to keep my planning in order to keep costs down. And finally, 10% say I'm an advisor here to learn to better serve my clients. So welcome everybody, for whatever reason that's brought you here today. Steve, I'll turn it over to you. I'm going to give you the presenter rights.
Thank you so much, Jeff.
Okay.
All right, I think you've given me those rights, and I'm going to go to my slideshow and start my slideshow. And Jeff, can you see that now?
I can. Looks
good.
Thank
you so much, very much. And good morning, everyone, and happy Wednesday to everyone. It's March 1st, as Jeff just said, and it is hard to believe, but spring is coming, they tell me, and in some areas I think has already sprung. So good morning, and Jeff assures me this morning that he's already been on the practice tee for his golf, and his son is also a big golfer. So it's that time of year, and we welcome you this morning, wherever you are. And we know your time is very valuable, so it's my great privilege to present to you today on this very broad subject. So we're going to waste no time getting started because we have lots to talk about. You may have questions as well. And I just want to give some preliminary comments here. Many of you, as Jeff just ascertained from the survey that was given, many of you have served as an executor, or you're expecting to serve as a fiduciary, a personal representative, as we call it in Maryland, or a trustee of a trust. And many of you, again, anticipate doing this in the future, or you have reasons to want to plan in your own estate planning for the minimization of costs, if that's one of your goals, or the thorough administration of your estate or trust. So no matter where you are or who you are this morning, I hope to give you a mental framework. And for those advisors or CPAs that are on the webinar this morning, we also want to, just for our own professional best practices, always form a mental picture. So why am I saying this morning? Well, the one reason that I feel that this is a very important workshop is to give people a framework of what administration really is. So there's lots of mechanics that we could talk about this morning, and we will. There's lots of little nuances, and this is a very broad topic to try to cover within an hour to an hour and 15 minutes, which we will. But I'm going to give you this very broad overview, and the thing I want you to walk away from, or walk away with today from this workshop, is not necessarily the mechanics. Yes, you have your worksheet, and yes, you have some handouts here, some critical date checklists, which I want you to know are tools. And of course, the Register of Wills has checklists, and the various resources on the internet have checklists for trust administration. So this is just a mental checklist. But the thing I want you to walk away from is knowing that there is a kind of a mental framework that you have to have about administration, and also that administration is process driven. Administration is process driven. So if you can kind of say, well, gosh, there has to be a certain mental framework I have to have about my this particular fiduciary duty, whether it's an estate or a trust, and that it's really process driven. It's It's not necessarily exciting. It's not necessarily a lot of fun, especially if you have lost a loved one recently or at the time of administration, you have yourself passed away. This is not a fun time, but it can be rewarding in the sense of doing a very high and best job in the administration process and understanding that it's process driven can take away a lot of stress. And in talking about all of this, I want to say, what is administration? And this is again a preliminary comment. What really are we talking about here? Well, administration, in my opinion, is the third phase of estate planning. So what we're talking about here this morning is not the first phase, which is the planning and design phase. Someone created a will plan, or they created a revocable trust or other plan. And they designed that and they implemented it. And then hopefully during their lifetime, that person or family maintained that plan. So we had the first phase, which is the implementation, the second phase, which is the maintenance and updating of that estate plan. And then the third phase is the fruition of that plan, which is the administration phase. So that's what we're really talking about. So all of those things that I just mentioned kind of lead me to this final preliminary comment, and that is in forming this mental framework of administration. I like to analogize this to conducting an orchestra. Now, I've never actually conducted an orchestra, but fortunately through my friends that I have met through WBJC and other friends of Elville and Associates, I've actually met several conductors, and I've also I've really wondered what is that like. But if you can imagine conducting an orchestra, I'm assuming most of you have never done that. We have various pieces and various instruments and various sections and various nuances of that. And of course, conductors are extremely important. They are extremely talented and they have to know the music and they have to know it inside out. So they know that there's a process and they are nuancing that process as they go through their symphony or that piece of music. So that's what I would, at a very high level, analogize this morning to, is you are the conductor, or your executor or trustee is the conductor of that orchestra. And looking at it from that point of view, we can get rid of a lot of the stress that's involved if we understand it from that perspective and that it's a process. So thank you for sitting through that introductory series of comments of mine. And Jeff is a great moderator. He has moderated hundreds or even thousands of these types of webinars. So please ask him your questions as we get started. We are going to stop periodically, and this is informal. So I want you to just relax and understand that we are going to pass along now the framework and the process of administration. So this is not legal advice, only because I cannot engage in an attorney-client relationship with anybody on this webinar, but we are certainly going to do the best we can to answer questions in a very general way, and then to be able to take further questions or engage in an attorney-client relationship or a fiduciary relationship after the webinar. So we're going to talk about what this mystery is of administration and what happens after the death of a loved one or the person who has died, even if they are not a loved one and you're serving in a fiduciary capacity. We want to minimize confusion and we want to maximize support. All of this goes back to my preliminary comments about a process-driven system here. We're going to talk about the legal steps and what is the legal process. We're also going to talk about practical steps. You know, it's not all just legal. There are a lot of practical things that happen in administration, and I strongly encourage you to think about both sides of that coin. We're going to talk about the most significant legal things that happen, the most significant tax issues that anyone, a fiduciary or an advisor, should be aware of after the death of a person or the death of a client. And how personal representatives, trustees, and advisors, and CPAs, how can they all work with attorneys and attorneys work with that team to provide the most support and the highest and most practical approach to administration. So administration is one of our clients' greatest concerns, or maybe if you are not an advisor or an attorney on this call, which I assume most of you are not, although I know we have some advisors, this is one of the family's greatest concerns. This is one of the person's greatest concerns who does estate planning. What that person really wants to know, in my opinion, is once I engage in this planning, will it really work and will it take care of my loved ones? That is really the pain point. That is really the thing the person is concerned about. So what we're really talking about here as the third phase of planning is arguably the most important phase. Of course, all the phases are important. So when we get to the third phase, that we actually have an estate plan that works. Now, whether that estate plan has been properly done or whether it was only partially perfected, which we don't want, that's not going to matter at the time of administration, because at the time of administration, we have to deal with the situation that is before us. And that's why I say there are legal aspects of administration, and then there are practical aspects where we have to kind of improvise as we go along. There is a highway, there is a lane that we're staying in, but that lane is not always going to be right down the middle. So we have to try to stay in the lane, but we are going to at times deviate back and forth in that lane. Now, with a will, we have probate. This is the very notion of the process of the administration for a will. And as you will see in the examples we're going to lay out this morning, there's also probate where we have no will if we have probate assets. We're going to talk about trust administration. Many of you on this webinar have a revocable trust, or a revocable living trust, we call it, as an alternative to a will. And there is a similar process. Many of you have implemented trust plans on the idea that you can minimize the process or minimize costs, and that can be true, and that is true, but we have to understand that there is still a process. And then we're going to understand the transitionary period. So I call this the period after someone dies. If you would allow me to use my hands, this is the life of the individual, and now that person has died, and their estate, or their trust estate, as we might call it, has to be administered. And this is the administration period, and this is the transitionary period. And if I may say so, at least in trust administration, this is, in my mind, the greatest of all questions that clients and individuals have, families have, about trust, is what happens when I die. This whole idea that the trust now becomes irrevocable, if it wasn't already irrevocable, and it has to be administered through a process. This is the transitionary period, and we're going to talk about all of that and try to put that into a perspective, okay? So I want you to think in terms of, at a person's death, if they have a probate estate, that probate estate has to be administered in a certain way in accordance with the law. And if that person has no probate estate, the estate will be administered, or the trust estate, I should say, will be administered in accordance with the laws and the rules of trust administration. And that transitionary period, or that administrative period, may be long or it may be short. So who will be there for the surviving spouse if the person is married, and or the children? So these are things that need to be thought about in those first two phases of planning. And if you're an advisor on this webinar, these are the things we want to advise and think about for our families, individuals or families. And what does that person do? What does the family do? How should they think about that time of crisis? Okay, and we're going to be prepared, and we're going to be prepared through a process. Okay, not the circumstances. See, the circumstances are what can make the surviving spouse or the surviving family members very unhappy with being overwhelmed. And this is, I guess, the process of easing the suffering for the survivors. And we can do that through a process-driven situation, or process-driven education, planning, and organization. And that's why I'm going to go back to these handouts now. And I don't want you to be tied to these handouts as if these are the only process type information that's available. But I want you to be aware again, the whole purpose of this webinar is to get into our minds that administration should be driven by a process, that it's like orchestrating a piece of music from beginning to end and doing it with the proper boundaries and the proper fiduciary responsibility. So just take a glance at this, get familiar with it. Don't get stressed out about anything that you see, and just know that these are established parameters. These are not things that are new. These things are established. Although there are laws that occasionally change the process slightly, the process in and of itself is pretty well established. Now, we're going to go through some cases, and as we give these webinars on a quarterly basis, Jeff gets lots of comments from attendees, and some of our attendees want to focus more on the examples. Some of our attendees want us to focus more on the process. So I'm going to try to do a happy medium here of both. But the point of these examples is really not for you to remember all the details. And of course, these are only 4 examples that I'm going to give you this morning as we get into the specifics of these examples. I want you to walk away with a feeling that you understand the difference between the various scenarios that could be presented to your personal representative / executor or trustee at the time of your death, or that you may take on at the time of your fiduciary taking on of that responsibility. Now, this is not 100% scientific, but I have seen many estate plans, many administrations, and I see that some of them are very plan specific. The structure is very clear, it's very straightforward, there are really no ambiguities. And then there are structures that are maybe clear, but they're driven mainly by certain types of assets. So many of you may agree on this webinar this morning that a lot of people, a lot of folks have retirement type assets that are really dominating their estate plan. They have more retirement type assets than they have non-retirement assets, meaning they have more 401k or 403b or IRA assets than they have any other type of asset. And then, of course, there are estates and trusts where there's the opposite. They have many more non-retirement assets. A good example of that is someone who invests in real estate, someone who has never really had a big interest in retirement plans, and they've really just invested in non-retirement assets such as stocks and bonds and so forth. So we have these variations in what is really driving most of the administration. So we have to be aware of that. And then we have maybe what I would call needs-specific plans, where you or someone that you will appoint will step into the fiduciary role, and they will see a situation that was much different than it was anticipated. And this is why, again, I'm emphasizing it's more important to think about the mental framework. It's more important to think about that we have a process-driven plan that's going down that highway. It's just a question of what lane are we in. And we have to be aware that situations in planning, in administration after the planning, are not always what we anticipate will happen. So we have to be flexible. And we have to be at least flexible within the framework of the orchestration that we're trying to do. Or it's more fact specific, that there was something that actually caused this problem. There was a problem. Maybe it is not just something that was unanticipated, but it's just poor planning. And now we have to make judgment calls. So again, I'm setting the framework as we get into more specifics now. And as I get into the first hypothetical example, I don't want you to focus on the names of these individuals. I only want you to look at the framework. It's kind of like an artist who sits down and they kind of block in the big things in the picture, and they haven't really focused on the specifics yet or the fine details. So that's what I want you to do here, is kind of think of yourself as blocking in if you were painting a painting. Okay, so here we have a single person who was never married. This is a single perennial bachelor. He was married. He had one child. And look at this from a very high level point of view. He had a residence. He had non-retirement assets of $200,000. He did have an IRA. His IRA is more than his 200,000, but look at the savings bonds. This individual actually had significant savings bonds, and we see that even in this day and time, people still see many times savings bonds as a good investment. He never made any lifetime gifts. He had no creditors at his death. Remember that creditors can be and will be notified at death in an estate, and we're going to go over that. But here he had no creditors. His income was Social Security, and he leaves everything to his son outright. This was a very straightforward plan. Now, what do we know if we are a personal representative of this gentleman's estate? Because he had a will. Well, first of all, we know the house was in his sole name. Let's just make that assumption. All of the assets were in his sole name. They did not have a life estate beneficiary. They did not have an account beneficiary. They were all in his name. So the residence will go through probate. The checking and savings and CDs will go through probate. The savings bonds will go through probate, because even though those are income in respect to a decedent, IRD, they have to have taxes paid on them at the time of death. Those are still going to be probatable assets. The IRA, let's make the assumption that it was beneficiary designated. So it looks like we have a probate estate here of about $850,000. Now, before I get too far ahead of myself, there may be people on this webinar that don't know what the probate process is. Well, we're going to get into more specifics about that. But remember that probate is the process of proving a will to be valid. Probate is the process of proving a will to be valid. And notice has to be given, and notice to creditors has to be given. And probate will occur even if this gentleman had no will. Now, in this example, he has a will, but if he had no will, would he still have probate? And the answer is yes, because probate assets are what? Probate assets are assets in the person's sole name, assets in the person's sole name, with no joint owner, clearly, and no beneficiary. Assets that are in someone's own name with no probate, no joint owner and no beneficiary. Now, as we look at the IRA here, what if the IRA had no beneficiary? And this is no small thing in the post-COVID era. We have found that some very high-level firms of the past are no longer as efficient as they were, and you have to be careful. If you're doing planning during life, we have to be careful to double and triple check our beneficiary designations. Let's pretend this IRA had no beneficiary. Would it go through probate? Unfortunately, yes. If it had no beneficiary at all, it would go through probate, and now we have an acceleration of income tax. So this example shows what goes through probate because this person died with a will, and we know that even if he had no will, there would be probate on the probate assets. The savings bonds, I don't want to skip over really quickly. Many of you may have questions about how savings bonds would be dealt with, but to be very quick about this, the savings bond tax has to be paid, and that can be allocated between the estate of the person who died, the person who died's final tax return, and the beneficiaries of the savings bonds, depending on what the CPA or attorney calculates as the best way to handle the taxation of that income in respect to a decedent. Now we're going to move to a different example, and we'll get through these. These are examples of a couple, the next two examples. Here we have, and now remember, I don't want you to focus necessarily on all of the mechanics and all of the details. I just want you to block in as if you were painting your picture. So we have a married person who has died, and this married person had a spouse, and there were 3 children. Now, if we look at the bottom of this slide, we see that this couple had an estate plan. They had a revocable trust estate plan. Now, what do we know about revocable trusts? Well, they will only work if they are properly funded. if the assets that the couple owns, or the individual, but in this case, a couple, are properly aligned with the trust. So those advisors that are on this webinar, we know that if we don't have a properly aligned trust, that we're going to have an estate plan that doesn't work the way it's supposed to. So let's make the assumption that not only did this couple have an estate plan, they had a revocable trust, and this could have been two separate trusts, one for each spouse in the traditional sense, or it could have been a joint family trust, which are very popular even in non-common laws, in common law states like Maryland. Okay, so let's look at this. We have a residence that's in the trust. We have cash and CDs and savings. We have significant IRAs that are not in the trust. Remember, those IRAs cannot be owned in the trust. We have a joint brokerage account that is titled in the trust or trusts. We have life insurance, and that life insurance usually would not be titled in a trust, but would live on its own, just like an IRA, outside of the trust. And here we have a secondary home. We have a person here who lives in Maryland. We're just using Maryland as an example today. This couple has another house over in Delaware, the lower, slower shore, as they say. And so now we know they have a trust. Everything in that trust is outright. Everything is going to the survivor, basically. There's no complications here. There are no complex structures. There's not a marital trust for the survivor or a non-marital trust in this first example. But notice that the survivor has the ability to disclaim assets. Normally, the spouse would disclaim assets within a certain period of time by law for federal estate tax purposes if they wanted to disclaim for any reason, but usually it would be for estate tax. So I'll come back to that in just a moment. But here we have an example of a trust administration. Now, on the death of a first spouse, do we have a lot of administration in terms of the relative terms of what an administration would be? Well, probably not. Here we have probably a bare amount of administration. The spouse died. He left everything to his survivor, and that surviving spouse is just going to make sure that everything is now titled, in this example, in her continuing revocable trust. She's going to do what? She's going to make death claims on the 401k and IRAs. So she's going to make those death claims, and in our example here, all the IRA beneficiaries and 401k beneficiaries were done correctly. She's probably, depending on his age, and here we see that he died prior to his beginning date, prior to his required beginning date for IRA distributions, or required minimum distributions, I should say. And so the survivor here is probably going to roll over those IRA assets to her own IRA. Now, she can also take an inherited IRA because she's a spouse, but she's probably going to take a rollover IRA and keep things simple. She's going to make a death claim on the life insurance. So you see here on the death of the first spouse in a revocable trust situation where everything was properly funded and titled into the trust, we have a relatively simple administration. Now, this may seem simple to you and I, but for many people, this is a very complex situation. So we have to keep that in mind. And when we talk about the transitionary period that I mentioned very early on, we have to remember that after someone's death, and here we have a spouse who died, his interest in his trust becomes irrevocable, whether that is two separate trusts or whether that is a joint trust. His interest is irrevocable and it has to be administered. So this is very simple to understand once we get our minds around the idea that a trust that is revocable becomes irrevocable at the time of the person's death, and it must be administered. Now here, again, the administration is basically moving assets over to the survivor and making sure that she is healthy and well as possible and as stress-free as possible, and it can go on with her life. Notice at the bottom, the very bottom, I put in a bullet point that says formula clause. Many of you know what I'm talking about, but for those of you who do not know, it is possible for this couple to have had their trust plan that basically says on the death of one person that there would be a formula or further trusts for the survivor. So those trusts could either be what I would call a marital trust, if everything is going to the marital share, in a marital Q-tip trust, for example, a trust that's only for the surviving spouse. And that is many times what we see today based on the tax advantages of a trust like this for a survivor, to protect against remarriage and also to protect the shares of the children and to protect the survivor from the claims of creditors. Or that trust could, for various reasons, be a non-marital trust, something that we might call a bypass trust or a family trust or a residuary trust, as they used to be called in the past, and the modern term is the bypass trust. Now, why am I talking about all of those things? Because you're going to possibly see these things if you are a surviving spouse, if you are an executor or trustee of a surviving spouse. Here we're talking about trusts. And before we leave this slide, let's look at the estate tax ramifications of this particular situation. Here we have the death of the first spouse. And as we really step back from the mechanics of all of these facts that I've put out here, what am I really talking about? Well, Jack, the person who died here, let's assume that he had died in 2023. Well, Jack would have had at his death a federal estate tax exemption of how much? $12,920,000. This is the huge number that we have now for each spouse, $12,920,000, as the new federal exemption amount adjusted up from last year for inflation. The Maryland exemption remains at $5 million per person. So between this couple, they can both leave, assuming that it would be the same estate tax exemption at the survivor's death, they can leave nearly $26 million to their children without tax, without estate tax, and $10 million for Maryland purposes. Why? Based on a concept called portability. So portability in this example is the surviving spouse's ability to choose to utilize or port the exemption amount of the deceased spouse. I'm going to repeat that again. Portability is the ability of the surviving spouse, in this case Janet, to utilize or port the exemption amount of the deceased spouse, in this case Jack. She now has 5 years to do this. This is an extremely favorable law. It used to be required within 9 months. The government changed the rules to 24 months, and now a very favorable 60 months or 5 years to make the portability election. So why do I bring this up? Because in this example, if we have an outright distribution basically, or a formula clause, we still have to recognize that the survivor has the ability to exercise their right to port whatever exemption amount that this deceased spouse has to her own exemption, meaning she can utilize that exemption in addition to whatever she has at the time of her death. These are things that you need to be aware of as you take on the role of a fiduciary. Now, in this third fact pattern, we have the same couple. Now, there's a 20-year gap from the time of Jack's death, the first spouse to die. But look at this now. We have a survivor, Janet, who is still quite well off. She has quite a lot of changes that have occurred in her life since the time of Jack's death. She lives in a CCRC, a continuing care retirement community. Her assets are what they are. They're similar and actually greater than they were before because of the passage of time. She has her remaining life insurance policy, but look what happened here. She decided that she didn't like the Delaware shore and she was going to move to Florida. So she actually has a Florida residence that she still owns, but apparently here in this fact pattern, she lives in a retirement community, a CCRC. But look at the other changed circumstances. You see, 20 years have gone by, and one of the children, one of the three children, unfortunately has developed or has been injured in a car accident or other accident, or maybe some kind of personal accident, and now they have a brain injury, they have a disability. So as you're looking at this particular fact pattern, at first it may seem very straightforward. When Jack died 20 years earlier, the proper tax elections were made. But remember, in Jack's plan, everything went to Janet outright, basically. So she has continued on with her life, and now she has died. And her CCRC deposit is going to come back to the estate in my example, although there's plenty of CCRC deposits that don't come back to the trust estate. So we have to be driven by the process, driven by the plan documents for the community, the agreement. So what do we have here? We have cash, we have brokerage accounts, and we have the Florida residence in the trust. And we also hopefully have the continuing care retirement community deposit designated to the trust. And of course, everything is going to the children equally. Janet, in this example, will have no estate tax because she ported Jack's amount, and she has less than that exemption amount. She's leaving an IRA. That IRA is going to be claimed by the children. And the trustee now is going through a process. They are going through the process that we're going to actually talk about here in just a few minutes. And here we have to be cognizant of this disabled child. Now, in this example, and we'll move on, in this example, the couple did not anticipate this child's injury, and I don't know why they didn't. Perhaps they just never got around to it. Perhaps the surviving spouse was disabled herself and couldn't address this issue. But now we have outright distribution going to this disabled person. So we want to do anything we can do if we are a fiduciary. We want to do anything we can do to make sure that we can try to preserve assets for this person. Whether it is a decanting that might be helpful, maybe that's not going to be helpful at all, meaning an ability to try to create a situation where assets can be held in further trust. But the decanting may not help at all. And let's back up for just one moment. We're going to look at all the terms and provisions of the trust, and we're going to hope that there is a provision in there that allows us to set aside funds in a standby supplemental needs trust of some kind to protect this beneficiary. So the point of this illustration is to show what happens for the passage of time, what happens when the surviving spouse has had a new life for herself for 20 years, now passes away. Now there are going to be processes that have to take place. But look at this one little last point. We have several creditors at the time of Janet's death. So what do we do? And this is the best practices kind of discussion. Should the trustee of this particular administration give notice to creditors? And in my opinion, the answer is yes, because here we have a person who has a private document. They have a trust, but there is a provision now under Maryland law to allow for notice to creditors under a trust, and to make sure that if creditors don't make a claim for these types of debts, these types of things that remain at death, that they are foreclosed from making a claim. So this is just a flavor of what you're looking at as a fiduciary under these circumstances. And the last example is we have here a person who died with no estate plan. So this is one of those things that I mentioned earlier. This is kind of a fact-driven pattern where we have problems here. We have disconnect here. We don't have a huge estate to deal with, but we still have a probate estate because we have spouses here who are separated. We have children who are in bankruptcy. We have assets that are going to go by beneficiary designation, such as the inherited IRA, to the children. The car would go through probate because it was owned at the person's death in his own name, even though he has no will. His checking and savings will go through probate. It was in his own name. The savings bonds, we know those are going to go through probate. Now look, he utilized some lifetime gifts. So this person had substantial assets prior to his death, but he gave a lot of them away. So we have to be aware of what effect does that have on his taxable estate. Well, the answer is because he died with a $12 million exemption and he died with a $5 million Maryland exemption, assuming that he was in Maryland, this does not affect him, and he did not utilize all of his exemption amount. So his lifetime gifts only use part of his exemption, and he's perfectly fine as far as the estate tax or gift tax goes. So here we have a spouse who's kind of disconnected from the process. She's got to be notified. The children, one of them is in bankruptcy and unfortunately probably will lose their share to the bankruptcy court and the creditors. So these are the fact-driven problems that we can encounter when we are an executor. Okay, Jeff, now I went through that in great detail in the last 20 or 30 minutes just to give people on the webinar here this morning a real feel for the various circumstances that they could encounter. And of course, there's a myriad of other circumstances. I want to stop for just a second, Jeff, and see if there's any questions as we're getting ready to now look at the actual process.
Thanks, Steve. We do have one question. It is a pretty long question that's pretty specific, but I'm going to run it by you and see if you have any just general comments as we move forward here. I am the PR for my recently deceased mother. I have 3 sisters, and the will and trust name us to split assets evenly. Most of my mother's assets were in her revocable trust, and a few bank accounts were outside the trust. I'm in the process of closing bank accounts and redeeming the cash. The value of all assets is around $400,000. I've paid all known expenses and don't expect there to be any taxes due. At what point am I able to start giving my sisters some or all of their inheritance? Can I provide them some or all proceeds due to them as I receive them, or do I need to wait some point of time? Also, do I need to open an estate or trust checking account that the money will flow into and out of, or can I just use my personal checking for this purpose?
Well, thank you for that wonderful series of questions. I will answer as generally as I can because I can't know every aspect of what you're dealing with, and this is not legal advice. But I would say that definitely you should have a trust checking account because that's one of the first things you want to establish. You certainly should not use your own personal account just for keeping things clean in the process, so to speak. And I think as far as giving advanced distributions is what it sounds like that you're concerned about. Can I make advanced distributions to my sisters? Well, that's going to be very personal to you. Remember, you have fiduciary responsibility, and you're going to want to account for everything from the date of death, which we're getting ready to talk about, until the time of distribution, from the date of death until the time of distribution. And then you're going to want to have a release signed. And I know that sounds extreme, maybe, but we want to give you the ability to say, listen, I've done my job. I don't want to be held responsible or liable for anything else. I've been very transparent. Please release me from liability. So when you make an advance distribution, see, you are giving money to the beneficiaries in advance of doing the final release and the final accounting per se. And I know every situation is different. So just be careful. You have to make sure that you don't give away or distribute the funds that you may need later. And you want to make sure there's an agreement that if you needed those funds, that they actually would be refunded to you. But generally speaking, it sounds like a straightforward situation. Sounds like you have good relations with your siblings. And certainly there's nothing wrong with making an advance distribution as long as you understand your fiduciary responsibility to pay all taxes to make sure that everything is accounted for. Thank you for that great question.
Okay. Can we do a couple more here for briefly?
Yes, and then I'll go right through the rest of the material.
Okay. Can you include an LLC or S Corp into your trust?
That's a great question. And the answer is yes, you can assign an LLC interest to your trust. And now as of 2022, in the fall of 2022, an LLC can actually be a dispositive instrument. An LLC can actually be drafted where it will actually leave assets like a testamentary instrument. And with an S corporation, of course, is a corporation, and its stock certificates could actually be retitled in the name of a trust, or it could be made transferable on death, TOD, to a trust. That's a great question.
Okay. And can you please explain assets held in further trust for children, not special needs?
Thank you. So the answer to that question is when you establish what we might call a further or spendthrift trust for a beneficiary, and they have no special needs as per your facts here. This person is a person who's the beneficiary of a general needs trust. This is a trust that usually would be for health, education, maintenance, and support, for example, as a standard of distribution. And depending on how that trust is structured, it can provide asset protection for that beneficiary throughout their lifetime or throughout the length of the trust, depending on who the trustees are, whether there's a spendthrift provision, making sure that how the assets actually flow at the beneficiary's death. That's an issue that affects asset protection, believe it or not, and whether or not that trust has flexibility, such as the inclusion of a trust protector. So whether it's a trust for further beneficiaries under a will or the trust established under a revocable trust, that is what the concept is a further spendthrift irrevocable trust.
Okay. And last one for now from one of our advisor friends. Could you discuss the pros and cons when naming a trust for a child as a beneficiary of an IRA?
Yes. So when you say a child, I'm assuming you mean someone who's under 18. And for Secure Act purposes, someone who's under 21, because that's what the Secure Act now deems to be the age of a minor, is someone who's under 21. So this can be kind of a lesser than all evils approach. No one wants to have an IRA go into a trust for a minor where the minor at the time of the person's death is now going to get required minimum distributions. On the other hand, the minor is a eligible designated beneficiary, a class of exempted beneficiaries that get to stretch out the IRA assets until the time that they're 21. And if they're not a special needs child, they will then have 10 years from age 21 to 31 to take the balance of the assets out in the accelerated fashion that the Secure Act says. But the lesser than all evils approach could very well be, depending on the situation, that it does make sense to leave an IRA in trust for a minor child, even though it's counterintuitive to get the stretch on those assets for as long as possible, because when they turn 21, they will no longer be eligible for the stretch.
Okay, thank you, Steve.
Thank you. All right. In the interest of time, and I thank everyone for those wonderful questions that they really help our presentation. Let's talk about this concept at the time of crisis. We want to have empathy as a fiduciary or as an advisor. We want to make sure the client and the family have support. If you are a professional, we want to have the whole support of your firm, depending on how sizable or not that firm is. We want the family to know that their advisors are together, that they have resources, and that we collectively, if we are the advisors and the fiduciaries, have these resources and we can act as a coordinator and counselor. We want to assure them that they should take care of themselves. These are the loved ones, the survivors. There is no hurry in most circumstances, although many times there are real estate properties, the pipes have burst because of the winter weather. Something has happened where there has to be some kind of hurry, but in most circumstances, in my experience, this is not the case. And the surviving family members or the survivor can, be methodical and take care of themselves. The advisors, again, need to not only know that they've been notified and that all advisors are notified, but that they are coordinating together. Clients and survivors want to know that the advisors are not just there, but they are actually working together and actually talking to one another during life and after death. We want assurances, give assurances to clients and fiduciaries that everything is in order because of the first two steps of planning that were hopefully done. That funds are available, okay? That's part of the thinking. That we are assisting the fiduciary or the client with final arrangements, okay? And of course, attending the final memorial services. This is something that's really on the order of the highest and best thing as we are professionals or non-professionals that are involved. And working with clients and their families or the fiduciaries with family-related issues. There are many family-related issues that can either be mitigated or managed. So let's talk about the legal steps, and we're going to get right into this. Probate versus non-probate. Now, these are similar steps. I just mentioned to you again a few slides ago, and I'll mention again these checklists, which I want you to get a good feel for. And I want you to walk away from that review of those lists knowing probate has a process, non-probate has a process. They're similar and yet different. Use the checklist. Organization is the key. So if we're dealing with a probate estate, and many of you have been very patient now in this webinar, waiting for me to get to this point of not only talking about not only talking about examples, but actually getting to the process. So here we go. At the date of death, a death certificate is issued. And this is not meant to represent all steps in a probate estate, but this will give you a good feel of the process. The letter of administration is going to be issued, letters of administration, official letters with a raised seal. I'm talking about Maryland probate. We're not talking about Virginia probate, where probate is more relaxed. We're not talking about North Carolina, where I was talking to an attorney the other day describing their process. We're not talking about New York. We're talking about Maryland here because I'm in Maryland and barred in Maryland. There's an inventory and information report that's due within 3 months, and this is in a regular estate. Now, of course, there are streamlined versions of estates that are available under certain circumstances, but I'm talking about a regular estate here, an estate that is going to require all of the steps. So this inventory is due within 3 months. It tells the Register of Wills in an estate how much the assets actually are worth. When the estate was opened, there had to be a petition for probate. And when that petition was submitted, it gave an overview of what is thought to be in the estate, but not the actual values. And now in the inventory, we actually give the Register of Wills the values. And some of this is going to drag on, so maybe there has to be a supplemental inventory at a future time. The information report does what? It tells the Register of Wills who is subject to inheritance tax. Remember, Maryland is one of the only states that remains that has an inheritance tax and a state estate tax. The only good news is the inheritance tax has been abolished for many people in Maryland, but still applies to non-lineal descendants. So, or non-lineal descendant beneficiaries. So let's talk about now valuation. So there can be an alternate valuation. Claims against the estate have to be made within 6 months. A spouse can make an election. This is called the new spousal elective share law. This is a very big issue in planning for couples during the first 2 steps of the planning phase. It's a very big issue for you to know about if you're a fiduciary after the death of someone and there's a surviving spouse. That spouse, if they are not receiving a certain amount of the estate, they are entitled to make an election to receive at least that statutory minimum amount. Disclaimers have to be done within 9 months of the date of death for it to be effective for federal estate tax purposes, although they can be effective for state estate tax purposes, even if they are not done within 9 months. The federal and state estate tax returns have to be done within a certain period of time, or they have to be extended. The Q-tip election, I mentioned a few moments ago that this particular spouse had died and left everything outright to his spouse, or it could have been left in a marital trust. This is the election for that marital trust to be memorialized. It's done on the same form 706, as the portability election. And if we are dealing with a regular estate, the first administration account is due within 9 months from the time of the letters of administration. Further accounts are due. And then notice the bullet point down toward the bottom, I said release of liability for the personal representative or trustee. Especially in the case of a trustee, we want to have those releases of liability signed. Now remember that when a personal representative submits their first or maybe final administration account, and that is approved by the register and the orphans court, what's going to happen is the beneficiaries or the interested persons, they have a certain period of time to accept or to object. And once that period passes, now the estate can be distributed. There is a certain timeline for retirement plan accounts. Now, you might say, well, Steve, those retirement plans pass outside of probate. So how does the executor or personal representative become responsible for making sure those are obtained or are claimed? So let's talk about retirement plans. Retirement plans have to be claimed, and the new IRAs have to be set up for the beneficiaries by December 31st of the year following death. Now, this is usually a very, very long time from the date of death, but there's a time frame, and that time frame is that by September 30th of the year following death, beneficiaries are finalized. And we don't have time to get into that today, but that's an important date. And then by October 30th of the year following death, the plan administrator has to receive a copy of the documents. And then by December 31st of the year following death, that's when the IRA has to be broken out into separate IRA shares or established for the beneficiaries. So this time frame is important, and it's an ambiguous thing, in my opinion, about the responsibility of the personal representative to actually make sure that the beneficiaries are doing what they're supposed to do. And I think that it's kind of a quasi responsibility, and that they should do everything they can to make sure that the beneficiaries are making death claims on the IRA. Now, if the IRA is payable to the estate, unfortunately, because it failed for beneficiary purposes, then I think this is very clear that it is the personal representative's responsibility to make a death claim on that IRA. And then we don't have time to get into it, but the fiduciary needs to understand or make sure they've hired professionals to understand the effects of the Secure Act. Now, there has to be an income tax return for the estate of the person who died. This is called a fiduciary income tax return. And of course, the final tax return for the deceased has to be done. And then if there are estate taxes involved or taxes that are very significant, we want to have a closing letter from the IRS and from the Comptroller of Maryland. Now, as we're talking about non-probate, we're talking about now the administration of a non-probate estate. And for our purposes, we're going to say it's a trust. It's that very ambiguous thing that most people, even around the world, are very confused about. When I die with my trust, what happens? Well, here we see the trust became irrevocable, and now it must be administered. So is it possible to have a very short administration with a revocable trust? And the answer is absolutely yes. A prime example, in my opinion, is where there is a surviving spouse or a single person, and they have a trust, and that trust is fully funded. Everything is in there the way it's supposed to be. And just for example, there's one child. There's one child. That child's very cooperative, very much on top of things, and that revocable trust is funded at the time of death. That administration is going to be very quick. There is no other beneficiary to account to. Their final tax returns are going to be filed. It's very possible that that child who is the trustee of that trust, the successor trustee, they're going to distribute all the assets to themselves fairly quickly, and there's no elaborate process. But let's take the same situation and say that there were 3 or 4 children, and now there's going to be a broader process because the fiduciary involved, the surviving trustee, is going to want to make sure they've accounted for everything, all the expenses that were paid out, all of the items of income that come in, all of the notices that are required. Now see, in a probate estate, the Register of Wills drives the process of notices to interested persons. But here we have a private estate plan. We have a trust, and that trust also now under the Maryland Trust Act of 2014 has notice requirements. So let's go down through this. You'll see it's very similar. We have date of death values. We have to marshal the assets of the estate. We have to notify beneficiaries, these qualified beneficiaries. The trustees have to, by law, notify these beneficiaries. These qualified beneficiaries are not only entitled to notice, they are entitled to information. And in my opinion, they are entitled to almost all information without limitation. So this is a very important thing to understand since 2014, because prior to that, beneficiaries were not entitled to all of these notices and information basically under a trust administration, as strange as that may sound. So the trustee has to make sure they're meeting these notice requirements. And notice to creditors, remember, it's not required, but in the Maryland Trust Act, the Trust Act provides for the ability of a trustee to notify creditors to foreclose the claims of creditors, even though it's not required like it is in an estate. Now we have the alternate valuation date, the spousal election. Jeff, we do need to change this because this was not updated for today. That's my fault. But the spousal elective share, the new spousal elective share law has been effective in Maryland, and it was effective August of 2020. And so we want to make sure that we are making sure that we're dealing with the new spousal elective share, even as part of a trust estate. The Q-tip election will have to be made within a certain period of time. It's done on Form 706. The portability election is the same issue. All of these issues are the same as in a state, except for the notice to qualified beneficiaries and how that is dealt with as far as the notice to creditors as well. So hopefully what you're seeing here is that the framework that I'm trying to get you to take away is that there is this broad overview of how you have to look at estates or trusts, and that if you're dealing with a revocable trust that's fully funded and there's no probate, there's still a process, and that process could be shorter or longer depending on the approach of the trustee and depending on how many beneficiaries there are and notice requirements and so forth. Again, I mentioned this earlier, that in an estate, we have the final blessing of the orphans court. There's a final order for distribution, but here in a trust, there isn't. So in my opinion, if you're a fiduciary, before you make final distribution, you're going to want those beneficiaries to release you from liability, waive their rights, and also agree that they will refund assets if it needs to be done to make the estate or trust, in this case a trust, whole because of taxes or any other unforeseen thing that the trustee was not really cognizant of. So these releases and waivers and refunding agreements are very important. Everything else here is very similar. Now let's talk about the practical steps. We talked about the legal steps. We've talked about the step-by-step process and the checklist. What are the practical things that we need to be thinking about after a death occurs? We want to schedule a meeting with the surviving spouse. Notice that this is either the spouse or the fiduciary for the family, if there is no surviving spouse, or if there is a fiduciary other than the surviving spouse. Usually this would be an entire family situation within 30 days. So you'll notice this is not within 7 days. It's not within 10 days. It certainly could occur. I had a family meeting recently that occurred within a very short period of time, but it's very difficult for the survivors, and it does not generally have to occur extremely quickly. Coordinate with the other advisors. Make sure we're providing that support. Make sure the fiduciary is using the checklist for critical dates. And again, organization is the key. We want to have an inclusive process. Not all families get along. Most of them do, and it's a joy. It's a joy even at a time of crisis or tragedy. but not all families get along. So we have to decide if we're fiduciaries. We have to decide how inclusive are we going to be. And I would advise that given potential circumstances otherwise, you're going to want to be as inclusive as possible because remember, if that person is a qualified beneficiary, they have the right to all information anyway, or lots of information. There is no such thing as a quiet trust in Maryland. So we just want to be inclusive as possible. It's not always possible, depending on what the problem that the person has or their attitudes towards the deceased person or the process. But just remember that if this person gets an attorney, if you're a fiduciary and this difficult person gets an attorney to represent them, it is not always a bad thing. If you are walking the straight and narrow path, and if you're following your process, you have nothing to be concerned about, and this person may be able to communicate better once they have an attorney. Again, we want to make sure that we're exercising reasonable due diligence to make sure that survivors are taken care of, that they have resources, and that they address their own planning, but not too soon. And many survivors feel that they have to address their own planning very quickly, and it's very tragic at times. Some of them are prepared to do so, and some of them are not. And we need to be diligent in making sure that they are as stress-free as possible. Organization and general readiness during the first two stages of planning are essential, in my opinion. Document storage, ease of location of documents, stock certificates, bonds, other things that are seemingly getting less and less available in the new world that we're living in of electronic storage. But these kinds of things have to be readily available, and we have to know where they are. And we also have to be available and understand the digital age. And do we have a digital archive or a hard copy archive of the assets, of the digital type assets? And remember that fiduciaries have access to all of these things by law because of the new electronic Digital Asset Act of several years ago that Maryland became a signer on. And of course, if the person has electronic archives, we need to, as fiduciaries, to be able to access those things. So what are the most problematic legal and tax issues? So we want to be aware, of course, of the titling of assets prior to a person's death. And I know I've been very vocal about this in this presentation, but if you're a fiduciary or a potential fiduciary, or you yourself are thinking about this for your own planning, remember, do your due diligence in the first two steps of planning, and then that will pay dividends in the administration. It will pay dividends not only in ease of administration, but in minimizing the cost of administration. Minimizing the cost of administration usually involves the use of a revocable trust because the statutory fees in the estate world are fixed. So the statutory fees that are allowed for fiduciaries and professionals that are assisting those fiduciaries are fixed, but in a trust administration, you can minimize the cost of administration through due diligence during your lifetime, proper trustee selection, and all of the normal things we've talked about today. The valuation of assets after death, this is a key issue. If you were to say to me, Steve, what is the most important thing immediately after death, is taking control of the assets, getting them valued, and accounting for those assets. Caution in retitling of accounts and acceptance of life insurance. This is not such a big deal as far as the acceptance of life insurance in today's world most of the time as it used to be because of the portability and the huge estate tax exemption amounts that we have. But we do want to be careful that after the death of a spouse, for example, that the surviving spouse not retitle assets too soon. Our financial advisor friends and colleagues many times will be so diligent and so good and in trying to serve clients that they will actually inadvertently help the client retitle accounts too quickly and retitle accounts in ways that they shouldn't be, in ways that are contrary to the administration and the terms of the trust or will. So we have to be very careful about that. And then the acceptance of life insurance subject has to do with surviving spouses accepting life insurance proceeds very quickly, which is very human and very natural, but not having thought through the estate tax issues before they actually accepted the life insurance. And now, in very rare circumstances these days where a disclaimer would be needed, the surviving spouse cannot disclaim those assets that they have already accepted. So we have to be careful about the post-mortem process of how the assets are handled and that they're not handled too soon. Inheritance tax has to be paid. So the fiduciary has to understand that if inheritance tax is applicable, that in an estate, we have to notify the Register of Wills. There is a form that is basically fixing inheritance tax on non-probate assets, assets that are passing outside of the estate but are still subject to inheritance tax. And when we are making sure and facilitating that retirement assets are coming to the beneficiaries and that they've made their death claims appropriately, we have to make sure that they understand and that we understand how the inheritance tax is going to be paid, because that inheritance tax is basically due at the time that person accepts that IRA. So the inheritance tax can be apportioned. It can actually be apportioned to the beneficiary who is responsible for that inheritance tax, or many times it's not apportioned and the trust or estate is responsible for that inheritance tax. So we have to be careful about inheritance tax. We don't want the fiduciary to get all switched up and mixed up and not having paid the inheritance tax at the appropriate time because of penalties and also liability. The portability election, we talked about having 5 years to make that election. The Q-tip election has to be made, and with an extension, it can be made up to 15 months on the Form 706. And again, notice to creditors, we talked about that. So we want to communicate if we are advisors, or if you as a fiduciary hire advisors, which you probably would in many circumstances, we want them to communicate. We want them to have a methodology of how they actually communicate with each other, and the responsibility is really theirs to have a quarterback, or that all of the people that are involved in that team know how to talk to each other and communicate. We want to have a significant investment of time during the decedent's lifetime to ensure, again, that those first 2 steps are taken care of: the planning phase, the maintenance phase. And in situations where there is an illness, many of you have dealt with illness in your family. You know this better than I do in many cases, but where we're dealing with someone, if you're a fiduciary or an advisor, where we're dealing with someone who is dealing with an obvious illness, we want to make sure that we're expediting things and making sure that all coordination is possibly can be done during that person's life is being done, because sometimes death can occur sooner than later where we start to see an obvious illness. And if you are in that first 2 steps of planning, the planning phase itself and the maintenance and updating phase, if we encourage someone to use a memorandum of intent or a letter of wishes, whatever you would like to call this, this is something that can strongly guide us as fiduciaries. It's an informal set of instructions that is attached to a trust or a will that can provide further guidance about the decedent's personal goals, values, how they want this trust administration to work, and how they want future beneficiaries to be dealt with. We want to use organizational tools during life. We want family members and fiduciaries to be educated. We don't want a one-dimensional system. We want to have a multifaceted educational system to get us to the finish line at the time of administration, a plan that actually works. We want to have a systematic method during lifetime, not just at death, about how the advisors are dealing with one another and making sure the client is organized. We want to disseminate information, and we want our clients and their families to feel that they can have confidence. All right, well, my goal was to leave about 10 minutes for questions, and I hope that I've taken you around the world as quickly as I possibly can, but hopefully not skipping over anything, to give you that mental framework that I hope to impart with you today. And also for you to walk away with an idea here that if I'm thinking about administration, or if I'm choosing fiduciaries, if I'm choosing trustees or thinking about being a fiduciary myself, I'm going to be driven by process. I'm going to utilize my ability to deal with professionals and get the advice of professionals if I need so. And along those lines, we at Elville and Associates want to be a resource to you. If you have questions as a fiduciary or you're trying to choose fiduciaries, come talk to us. We can have a counseling session. We can use one of our high-tech conference rooms, give you time to really sit and think. We want to see any kind of existing estate plans that you have. We want you to bring your questions. We want to talk to your advisors. If you don't have a team of advisors, we want to help you form that team. But the main thing that we really want to do is give you the time to think, how do I be the best fiduciary I can be? Or how do I choose fiduciaries? And if you are a fiduciary right now and you're dealing with an administration, if you need assistance with that, we are here to be a resource. Jeff, I'm going to turn it back to you, and I thank everyone for spending their time on this beautiful, I'm looking out the window here, beautiful Wednesday, and I wish you a great week, the rest of the week ahead.
Well, thank you, Steve. Really good job as always in painting that picture for us about estate and trust administration, something I'm going through right now, and listened intently as I picked some information up from you there. So we do have a couple of questions here, and I'll say, as always, now would be your time to get your final questions into Steve, as we have a few minutes here. And we do have a couple I'm going to start with here for you, Steve. And the first one is, in the examples, I noticed that you included children in the examples. In my situation, I have no children, and my spouse died. All of his accounts were either POD or jointly owned. His auto was in his name only. Will the death certificate and the letters of administration suffice to get the car placed in my name?
Yes, well, I thank you for that question. I can't give you legal advice about that, but it sure sounds to me at a very high level, very general level, that there's not a lot to do because it sounds like you were a traditional couple, and I'm sorry for your loss, but it sounds like the administration in your particular case is very straightforward. And I think that other than being able to take a death certificate and make death claims, there doesn't seem to be a lot for you to have to do. So God bless, and it sounds like that you're well on your way to, kind of starting your life again at this point.
Okay, thank you, Steve. Next question, is the inheritance tax you mentioned on IRAs a state tax, example Maryland, that other states might not have? Does it apply to Roth IRAs?
Thank you for that wonderful question. And the answer is yes, it applies to IRAs of all kinds. And it is not something that many other states have. But it's just that if property passes that is either probate or non-probate in the case of IRAs to a person subject to inheritance tax, then the inheritance tax is due. And that's challenging with IRAs because the person has made that death claim, they have the IRA, and now the question is whether the person themselves is responsible for the inheritance tax or whether the trust or estate is responsible because there was no apportionment. So thank you for that great question.
Okay, thank you. All right, doesn't look like we have any other questions right now. As we're waiting for any final ones, I'll say, as far as our webinar series goes, this Friday, we have 10 mistakes to avoid when planning for a loved one with special needs. And that's a new presentation that we're offering in partnership with a financial services organization. Looking forward to that. And then the following Friday, March 10th, we have one of our more popular presentations, What Families Need to Know About Planning for a Loved One with Special Needs. Both of those presentations are offered by our very own Stephen Elville. As far as my follow-up, I'll be sending out our video from today and the slides and a little bit more follow-up information from today for you. As it relates to some questions, it looks like we have one more before we end here. And it says, does it matter where the trust is set up? Is it in the state of residence?
Well, thank you. I'm not 100% sure about your question, but if I'm extrapolating as much as I can on that, I think you might be asking if a trust is set up in a certain state and it's governed by the laws of that state, that trust is deemed to have a situs or a location in that state, and it is deemed to be driven by the state law of that state. So situs and state law. So, but depending on what your question really was, I think that what you might be asking is that trust administered under the laws of that state? And the answer would be yes, in most cases. For example, a Maryland resident would have a Maryland trust. Its situs is in Maryland, its location, and its state law is Maryland, and that would be the state of administration. So thank you.
Okay, very good. All right, well, that's gonna do it for us today. We appreciate your interest in Elville and Associates and our webinar series. As Steve mentioned, please let us know if we can be of any assistance to you in any way, shape, or form with any of your planning needs, be it estate planning, elder law, special needs planning, business planning, state and trust administration. Be happy to be of assistance to you. And we look forward to seeing you again on the Elville webinar series soon. Have a great day, everybody.